Thank you, Mr. Speaker. Colleagues, I rise today in support of Senate Bill 875B, which makes important updates to the Oregon Foster Children's Bill of Rights and the Oregon Foster Children's Sibling Bill of Rights. For a little background, the Oregon Foster Children's Bill of Rights was established by this legislature in 2013 and requires the Department of Human Services to adopt rules specifying the rights of foster children and directs the agency to periodically review the rules to ensure compliance with state law. Some of these rights include the ability to make oral and written complaints about inappropriate care, placement, or services, and to be provided with contact information for adults who are responsible for their care, including caseworkers, attorneys, advocates, local citizen review boards, and DHS foster home certification staff. And in 2017, the Oregon legislature enacted the Oregon Foster Children's Sibling Bill of Rights, which further establishes the rights of siblings in foster care to maintain contact and be placed together when possible. Senate Bill 875B, if passed, adds additional rights to these bills of rights. For the Oregon Foster Children's Bill of Rights, it codifies 7 rights, some of those being the right to be protected from abuse, exploitation, neglect, intimidation, and the inappropriate use of restraint and seclusion, regularly attend school and have access to a free and appropriate public education, the right to be present at court hearings, and the right to have a placement there. It also expands the definition of foster child for the purposes of the Foster Children's Bill of Rights to include children who are awaiting placement in substitute care and children in physical custody of DHS. And it requires that a foster child receive a document explaining their rights within 7 days rather than the current 60 days. And for me, what I feel is one of the most important aspects of this bill is its modification of the Oregon Foster Children's Sibling Bill of Rights. I have spent the last few years speaking with foster youth who have experienced the system and their families, and it was clear that one of the hardest, most painful parts is losing contact with your siblings. Senate Bill 875B says that sibling contact is presumed to be in a child's best interest, and if it's going to be limited, a judge has to explain precisely why in writing. It clarifies that notification to siblings about special events like the birth of a sibling be made in a developmentally appropriate and trauma-responsive manner. It ensures that kids know their rights, can access them, and that those rights follow them, whether they're entering care, changing placements, or trying to stay connected to the people who matter most to them. The introduced version of the bill also included a right for foster youth to decline to attend religious events that don't align with their own beliefs. Colleagues, I bring this up because that was a carefully crafted provision and it was duplicative of existing DHS laws and rules. Legislative Counsel confirmed that while DHS has administrative rules encouraging placements that reflect a child's background and culture, those rules are agency-controlled and subject to change. The version we had in Senate Bill 875A would have put that right into statute, making it permanent unless changed by future legislation or a court ruling. I would, and many so, would have been proud to include that language. But we also recognize the real concerns that emerged during the last-minute discussions, including very real potential conflicts with foster parent rights and a still unfolding federal legal landscape. Right now, the Ninth Circuit is reviewing the Bates v. Paxaresh case, which involves a foster parent applicant challenging DHS's rules as infringing on that foster family's religious beliefs. The district court in that case sided with DHS, ruling that their rules were neutral and appropriately focused on the child's rights. But the case is still pending an appeal, and other related cases are expected to be taken up by the U.S. Supreme Court. And we were mindful of that as we amended this bill. Removing the religious autonomy language was not a decision the entire committee made lightly, but it was made to protect the broader bill and to give DHS space to thoughtfully implement the new rights of this bill put into statute without inadvertently triggering litigation or regulatory backlash that could delay protections kids desperately need right now. Organizations like Disability Rights Oregon, CASA, and Youth Rights and Justice have all backed this bill because they know what it looks like when the system works and what it looks like when it doesn't. And they know this bill is a step in the right direction. Colleagues, our foster youth deserve better than what the system has too often handed them. They deserve a sense of control, they deserve connection, and they deserve dignity. At the end of our hearing in Early Childhood Human Services, there was a commitment by everyone on that committee to come together in the interim to get that language right, to wait for the decision of the Ninth Circuit Court. and to make sure we come back in the short session to make sure that we are codifying religious beliefs into statute. Thank you.